A housing authority can request information about any person seeking to receive social housing supports or who is currently receiving social housing supports. A local authority can request certain information from a number of specified bodies when it's carrying out its functions as a housing authority. The local authority is given that power to request that information under Section 15 of the Housing Miscellaneous Provisions Act 1997. So the 1997 Act sets out a number of specified bodies to whom the Housing Authority can make this request for information. And those specified bodies include An Garda Síochána, but they also include the Criminal Assets Bureau, for example, the Minister for Social Welfare, and the Health Board. In our experience, however, these requests are most often made to An Garda Síochána. And in terms of the information that they're requesting, generally, it's information around previous criminal convictions of the household. So it's a very significant power because a local authority can make decisions on the basis of the information contained in that Section 15 report. A local authority can decide to refuse to allocate or to defer allocation of social housing to a household. Another example is a local authority can decide to suspend a household from the social housing list on the basis of information contained in that Section 15 report. So the Housing Authority are entitled to request information about any person seeking social housing support or availing of social housing support, or any person who the Housing Authority believes may have engaged in antisocial behaviour. So anyone in the household can be the subject of the Section 15 report. A local authority, in the exercise of its functions as a housing authority, can make this request for information at any stage. However, in our experience, that request for information is generally made when the housing authority is about to make an offer of allocation to a household. So if you become aware that you are the subject of a Section 15 report and that the local authority or the housing authority has made a decision on the basis of the information contained in that Section 15 report, you are entitled to ask the local authority for a copy of that Section 15 report, and the local authority is required to give you a copy of that Section 15 report. You're also entitled to appeal the decision that is made by the local authority on the basis of that Section 15 report. It's absolutely crucial that you get a copy of that Section 15 report so that you know exactly the reasons for the local authority's decision, and that you can launch a full and robust appeal of that decision. So if the local authority is refusing to give you a copy, to disclose a copy of the Section 15 report to you where you've requested it, you should remind the local authority that you have a right to see a copy of that Section 15 report under fair procedures. And if the local authority continues to refuse to provide you with a Section 15 report, we suggest that you seek legal advice. In addition to that, you're also entitled to make a request for a copy of the Section 15 report under the Freedom of Information Act, and we recommend that you do submit that request in tandem with making the request as a matter of fair procedure. And if the local authority again is refusing to provide you with the Section 15 report under the Freedom of Information Act request, we suggest that you may wish to consider appealing that refusal, because there is no general lawful basis under the Freedom of Information Act for a local authority to refuse to disclose that Section 15 report where requested. So recently, we were delighted to have a positive outcome for one of our clients. She had been suspended from the housing list by the local authority on the basis of a Section 15 report, I should say. And we appealed that suspension, and thankfully, after 6 years in emergency accommodation, she has just received an offer of social housing. However, in our work in assisting this client, we encountered a number of difficulties in gaining access to that Section 15 report, and that created huge difficulties for our client in terms of submitting a robust and full appeal of the suspension. So at no point was our client given the opportunity to read the Section 15 report, to review it. As I said, that severely hindered her ability to submit a full appeal of the council's or the housing authority's decision to suspend her from the housing list. This issue frequently arises in our legal advice clinics. So it is an issue being experienced on the ground. There are a number of other kind of fair procedure concerns in relation to how those Section 15 reports are used. We had one instance where a client was suspended from the housing list on the basis of a Section 15 report. But the offences contained in the Section 15 report were road traffic offences. And it's arguable whether someone's road traffic offences, which are relatively minor, should fundamentally impact their ability to access, social housing. So some people, when they find out that they've been the subject of a Section 15 report and a decision has been made, they receive a letter from the Housing Authority. It might not be immediately clear exactly what that relates to. The letter from the Housing Authority itself will generally indicate that a decision has been made under the Housing and Miscellaneous Provisions Act 1997, and it will generally cite Section 14 of that Act. So if you receive a letter that includes reference to Section 14 of the Housing Miscellaneous Provisions Act 1997, or a letter that says a decision has been made on estate management grounds, that can tip you off that Section 15 might be at issue here. So I recommend that if people do receive that letter or a similar letter, that they urgently seek legal advice in relation to that letter, because there can be quite strict timelines around submitting an appeal of that decision. Sometimes the letter itself sets out the appeals mechanism. So it sets out, for example, you have 21 working days to appeal this decision or something to that effect. But some letters don't actually confirm that timeline. But again, what I'd suggest is that if you do receive that letter, you urgently seek legal advice, but you speak with a solicitor as soon as you possibly can in order to ascertain your next steps. We ultimately made a complaint to the Office of the Information Commissioner on behalf of our client in relation to the Council's refusal to disclose the Section 15 report further to our request under the Freedom of Information Act. And following investigation by the Office of the Information Commissioner, the local authority actually reversed its decision and provided our client with a copy of the Section 15 report. And more significantly, the local authority themselves actually reversed its policy to not disclose Section 15 reports where requested. They committed to disclosing Section 15 reports going forward where requested, which is a significant outcome for other households who may find themselves in similar situations. Further to that outcome, we actually engaged with the Housing Agency and the Department of Housing, requesting that all local authorities be reminded of their constitutional obligation to provide Section 15 reports where requested, and hopefully that will bring across, I suppose, greater consistency across local authorities and how they deal with these types of requests, and ultimately increase transparency in decision-making processes.